Case study presentation by Alicia Buster. The parties involved in this case are the New York Times, a daily newspaper published in New York City, and Montgomery, Alabama City Commissioner L.B. Sullivan. For a plaintiff to prove defamation, the statement must be written, false, injurious, and unprivileged. In regards to public figures, as in this case, the plaintiff must also prove actual malice, meaning the person and entities that make defamatory statements have to have prior knowledge that such statements are false and still published without regard to the statement's falsity. The facts that led to this case involved an advertisement published by the New York Times in support of Martin Luther King Jr.'s campaign to end racial segregation. The advertisement was signed by many public figures, such as Eleanor Roosevelt and Jackie Robinson, in support of the campaign. The ad included facts about actions taken against civil rights protesters and Dr. King. Many of the protesters were students of Alabama State College, and protest leaders were said to be expelled. When peaceful protests on the Capitol building occurred, protesters were said to be met with police armed with shotguns and tear gas ringed the Alabama State College campus. Also, when the entire student body protested the state authorities by refusing to re-register, their dining hall was padlocked in an attempt to starve them into submission. Though the ad never mentioned Sullivan's name, he felt the advertisement referred indirectly to him by using the word police. He reasoned that the use of the word referred to him because of his status and supervisory role in the police department. The ad also mentioned multiple arrests and violent actions taken against Dr. Martin Luther King, such as bombings of his home and assaulting his person, which implied that the police had committed these actions as well. The Alabama courts deemed the ad libelous per se, and Sullivan was awarded $500,000. The New York Times appealed the decision, and the U.S. Supreme Court decided that the actual malice was needed to be provided in this case. It was determined that the New York Times had no reason to believe that the statements were false. The courts recognized that under the First Amendment, publication should be protected from defamation lawsuits in regards to public figures, as long as statements were not published out of malice. The parties involved in this case are Elma Gertz and Robert Welch, Incorporated. Gertz was the lawyer procured by Robert Nelson's family for civil litigation against Nelson's murderer. Welch is the founder of John Birch Society, an anti-communist group. Welch's society published defamatory statements about Gertz. The defamatory statements were published in the American Opinion, a monthly publication of the John Birch Society. The article was called Frame Up, Richard Nucio and the War on Police. The article stated that Gertz was a member of Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society, which was advocated the violent seizure of our government. The article called Gertz a Leninist and a communist fronter. The article also inferred that Gertz was a leader of the National Lawyers Guild, a communist organization, and stated that he probably did more than any other outfit to plan the communist attack on the Chicago police during the 1968 Democratic Convention. The managing editor never made an attempt to check facts and relied on the author's previous work. As the petitioner of this case, Gertz was deemed to be a private person on the grounds that his service on city committees nor his involvement in a high-profile case makes him a public figure. Gertz could not be seen as a public figure because there is no evidence of a fame or notoriety in the community. The allegation against Gertz hindered his career by damaging his reputation as a lawyer, and caused speculation from peers and friends. To avoid a lawsuit, Welch could have checked the facts of the article before publishing. He could have also printed a retraction once suit was filed. Georgia's defamation law follows general elements of the law: written or spoken false statements that it is injurious and unprivileged. In regards to defamation per se, Georgia law also followed standard elements such as charges another person with a crime punishable by law, charges another person with having some contagious disorder or with being guilty of some debasing act, which may exclude him from society, or refers to the trade, office, or profession of another person and is calculated to injure them. In addition to these elements, Georgia includes statements suggesting that one is guilty of a crime, dishonesty, or immorality, or accusing someone of having sexual relations with another person other than his wife. In regards to public figures, Georgia follows the New York Times versus Sullivan case and requires actual malice to be presented for damages to be awarded. From both of these cases, I can learn to make sure that everything that is printed or said is truthful and can be proved. Without proof of the truth, I can open myself up to lawsuits of defamatory nature, especially when speaking to private persons.